John Lindsay. John, why don't you tell us a little bit about your business?
I'm an intellectual property attorney. I help clients understand what is their intellectual property, and I help them then follow through on the steps that are necessary to protect that intellectual property. And typically that's done through patent law, trademark law, copyright law, and technology law.
And how long have you been in this business?
I've been in the legal aspects of the business for about 5 years, and before that I was in the technology aspect of the business as an engineer for about 10 or 15 years.
Gotcha. So how'd you end up getting started as a lawyer?
Well, I was actually working on a technology project as a software developer, and I had met with some old friends, and we were debating about our futures and how we might leverage our current backgrounds to provide additional value. And they brought up the idea of being lawyers. I thought it was a little odd at the time and asked what they would see me doing. And because everyone associated me with technology law, they said, duh, technology. And after I finished that project, I was in law school.
Gotcha. Okay. Can you describe what your typical customers are like?
I have a range of clients, but one of the typical customers that perceives a lot of value in my background tends to be a small business with a small to medium-sized patent portfolio. They have a breadth of technologies, and they are attempting to commercialize those technologies, and they engage me in the beginning to assist them.
And if somebody's coming to you, what are the typical kinds of problems or issues that you can help them solve or avoid?
One of the key steps is understanding who owns the intellectual property. That's a very common problem. The next problem is, in fact, understanding what is intellectual property. So when people have a certain business model, they want to understand what are the protectable elements of that aspect, and I help them through that. And after those key steps, we then explore the question that's typically asked is, how do we then protect that intellectual property? And then we hit that head on.
Now, obviously, there's a lot of lawyers in every city. Why do your customers select you over your competitors?
Well, there are a couple of advantages. One, that I have a breadth of technology so that I can handle multiple issues. I was a hand-on software developer and engineer for about 10 or 15 years. I also have a degree in chemistry, and I've also built some light electronics, so I have a wide technical foundation. And then also from a business perspective, I owned a small business. I've also worked in large businesses such as IBM, and then also I worked in project management. So it's a combination of law, technology, and business that businesses can perceive that value.
And have you had customers come and use you once they've used you before? So have you had repeat business?
Definitely. One of the misnomers is that once you file a patent application or file a trademark application or draft a license, that's it. Well, it's an ongoing process. Typically, when someone creates intellectual property, they will also monetize that intellectual property, and there are a lot more additional steps than just merely some individual single filing and then you're done. It's an ongoing relationship typically, especially for businesses who are building intellectual property over time.
Now, there are a lot of baby boomers that are retiring right now, and it's a question I always like to ask is, do you see that affecting your business in the next 12 to 18 months at all?
Yes, it could in two ways. One, a lot of those baby boomers are retiring from technology businesses. They've had ideas for businesses in their mind over time that they've not been able to pursue. And now that some of those baby boomers will be retiring, they're going to pursue that. Or perhaps they've even worked at a technology business and there's been a lot of layoffs there and they want to pursue their business. And for those reasons, I think some of those baby boomers will contact me to pursue their business.
And if somebody's watching this video, what'd be the one thing that you'd like to be sure that they remember from seeing it?
Call me sooner rather than later. There are some important factors that can't be resolved after the fact. For example, in patent law, if you publicly disclose your invention, there's certain protections that cannot be secured once you've made that public disclosure. The other fact is ownership of intellectual property. Make sure you contact me so that that can be properly documented when you're working with third parties.
That's great. Well, I appreciate your time today, John.
Thank you.